Welcome, everyone. Welcome, Ruwan. Uh, we are very happy to have today a discussion, a workshop discussion about the enforcement of the requirement to practice human rights due diligence. We are now with Ruha Subasinghe. I hope that I didn't misspell uh, your name. He is a legal director of the International Transport Workers Federation, ITF, and he is going to answer our questions today. I have a thank you so much for your time, by the way, and also for your video lecture. I think was very important because the enforcement mechanism at the sometimes the most important part at the end of the day for workers, right? So my first question is about these states' responsibilities. Now, is since the lack of budget and staff in the labor inspection office, there are a lot of problems with the law enforcement. No? So, what do you think that trade unions and other labor groups and activists can do to support labor inspections, no? And also health inspections, no? In those current times of COVID, please.
Sure. Thanks, Louis, and good morning and good day to everyone. It's a pleasure to be here with you today. And yes, and the question of enforcement, of course, is a critical piece. And I think it's important, especially in the context of human rights due diligence, which I hope I can use the acronym HRDD going forward, is that while we are campaigning for new laws around HRDD or how to implement the UN guiding principles, the OECD guidelines, or the ILO's M&E declaration, which I'm sure, well, actually I know were discussed in this module. The important thing is that while we look to bring about legislative change and to bring these soft law instruments to the hard law, is the fact that there's a lot of good existing laws on the books, but enforcement, of course, has been very poor. And this is one of the reasons why we need proper HRDD. And before perhaps highlighting how unions and civil society, I think that was a question, can be involved in assisting labor inspectors, I think as a starting point, we've got to say that labor inspection, if we look at this from a international labor standards perspective, right, the basis being Convention 81 of the ILO, is what's called a governance convention. It's been deemed so important. It's not a fundamental convention, it's a governance convention. I believe that there's up to 150 ratifications of this particular convention, right? And as part of that, one of the things, a requirement of the convention is to have labor inspectorates that are well-resourced with qualified inspectors who are independent, who are given the time, and who have the capability to conduct these inspections, which are critical in any economy, right? So then we need to ask the question, well, how is it that enforcement is so poor in so many countries if we've got 150 ratifications, almost 150 ratifications of this convention, and it is seen as a key critical governance issue? Well, there's various reasons for this. Tight budgets, austerity, but then we should also point out in the context of HRDD that many of the lead firms who source their products, say, from developing countries, developing economies, who set up subsidiaries in those countries, perhaps through particular legal structures, do so without paying adequate taxes. And what does that mean? That basically deprives state coffers of funds that can go into public services, including funding labor inspectorates. So the whole thing is almost like a vicious cycle sometimes. But I thought it was important to highlight that aspect before talking about how unions and civil society can contribute. So I think having said all of that, of course, there's different ways we can contribute. So if we look at, again, I'll use international labor standards sort of as a benchmark. Convention 150 of the ILO on labor administration, which has, I believe, almost 80 ratifications, calls for tripartite engagement. with the social partners in developing labor administration and labor inspectorates, right? So that's our starting point when we speak to our affiliates on the ground in pretty much every country, almost every country in the world, that this has to begin, the cooperation and collaboration begins at the macro level. Macro level is identifying priorities in terms of inspection, particular sectors, how we go about conducting inspections, and then especially on occupational safety and health, how we bring about frameworks on inspection on OSH. So that has to happen at the macro level. Then on the workplace level, or on the sectoral level, there's various ways in which unions and civil society can do this. This can be done in a very formal way. For example, an example which we talk about quite regularly is the mining inspectorate in Belgium, where worker representatives are part of the inspection teams themselves because of the intimate knowledge they have of working life in the mining sector. And this is by no means a unique example, but there are examples where in law, unions have a place within labor inspectorates, and they're bona fide members of labor inspectorates. And as such, we think that is a very, very good example of how an inspectorate can stay independent while getting access and knowledge of workers and unions in that space. So that's a formalistic way of doing it. The second way is, of course, through open door policies that labor inspectors have in consulting trade unions on the ground. An example that I can give from one of our sectors, which is road transport, and you can imagine with these being mobile workers, it's very difficult for labor inspectors to access, say, truck stops or areas where truck drivers usually congregate. So what we have is a system whereby we have trade union labor inspectors effectively assisting labor inspectors by providing real-time data and information on issues faced by truck drivers. And I'll use the example of the Netherlands, where in the Netherlands, there's a collective labor agreement for the sector, the trucking sector, where as part of the enforcement arm, trade union inspectors collect and provide this data to the National Labor Inspectorate, who can then take enforcement action based on data and information provided by trade unions. So this is an integral function that trade unions can provide to labor inspectors, and we're seeing very, very good results as a result of this. And I'm sure you've been reading in the press these days about so-called truck driver shortages, supply chain resilience issues, and this all comes into play now. And as we say, we're not talking about a truck driver shortage, we're talking about a decent work shortage, because we've been talking about these issues for decades. This is not anything new. This is not COVID related per se. So those, I think, are two ways in which unions can assist. And of course, where labor inspectorates are, where they do have enforcement powers. So for example, to issue fines, to present files to the prosecutor, we think that those kinds of labor inspectorates are probably the ones who benefit most from trade union and civil society engagement, because they can actually do something with it. But what do we need to do for that to happen? We, of course, need positive legislation at the national level that ensures that labor inspectors have those powers and can provide that service. So broadly speaking, I think I'm happy to leave it at that. I think now I think I've highlighted a couple of models in which unions can be involved, but nevertheless, I do think it's important to highlight that while unions and civil society and workers themselves can assist labor inspection, we must not forget that this is a function of the state, and trade unions should not take the place of labor inspection. This is a very important thing, because then we also run the risk of doing all the work when it should be public funds going towards national labor inspection to actually get the job done officially. Thank you.
Thank you. That is very important remarks, and also the last comment that you made about this is a state obligation, no international obligation. It's important. Just like a short comment. In Peru, for a long time, we call our Department of Labor like the James Bond because it just have 0.07% of the national budget, and a small part of that was for the labor inspection. So it was almost impossible for union for inspectors to do their job. No? And also they have a union, and they are always asking for more budget. No? Thank you for that comment. And now I am going to open for more questions and comments. Please raise your hand. So maybe, well, oh, yeah. Please, Philip, go ahead.
Okay, yeah, I hope you're not talking about the same tripartite alliance that we have in South Africa. We have the trade COSATU, which is an umbrella to many unions. We have ANC, which is a political party, and we also tripartite alliance. We have ANC and we have SACP, which is also a political group, but coming from communist background. And then it's a disaster. What happened is when they started, we have strong trade union, we have strong grassroots movement, but it was taken apart, left, right, and center. So if you're saying similar thing, I mean, for me, I'm very scared because it's going to be disaster. We are in disaster here in South Africa. When it comes to worker rights, and then also, you know, human rights and so on.
Should I take that question, Louis?
Sorry, I was muted.
Okay.
Sorry, Philip, but I think we should try to frame our question in the topic more closely to the topic of the labor inspections and the enforcement mechanism. So I don't know if you can maybe reframe your question or make another question.
Well, I mean, yeah.
I mean, yeah, we're talking about the trade union, civil society, to be responsible. I mean, to make sure that workers are protected. And then here in South Africa, like, okay, when you spoke of, you speak about the tripartite alliance earlier on, remember, you spoke about tripartite alliance, which to me is government, workers, and business coming together. And then which is a similar thing here in South Africa that we have. We have, I don't know what was the motive behind, but we have trade union, which represent workers. We've got government, which is the ANC, and then we've got communist organization, which is similar. It's a tripartite alliance. It's called tripartite alliance. And what we have now is a disaster. Workers' rights have been destroyed. And then again, you have basic human rights have been destroyed. So I don't know about the tripartite alliance. Can you talk more about the trip? Is it not going to be the same?
Sure. Yeah. Thanks for that, Philip. And I think, of course, within the South African context, the tripartite alliance of the ANC, COSATU, and the Communist Party is something quite different. It's, of course, it's a political alliance which, for historic reasons, brought together, you know, the two major political parties and COSATU together to lead the political change that the country to go through, of course, in the post-apartheid period. And I fully appreciate that. But I think what I'm talking about is more to do with something that also exists in South Africa, which is the collaboration between COSATU, the employer organization, and government when it comes to issues like implementing ILO conventions, but also the national level. What I was trying to talk about here was on developing labor inspection programs and the implementation of labor inspection. So what I'm trying to say is that if labor inspection to enforce labor laws, to ensure that workers' rights are protected, to ensure that workers' health and safety is protected, the best way to go about this is through a tripartite structure, through engagement with workers on the one hand and business on the other, so that when the labor inspectors go and do their job, they're informed by actually what's happening on the ground from an employer perspective and a worker perspective. That will make their job easier, it'll make their job more effective, and ultimately workers on the ground will have better terms and conditions and have their rights better enforced as a result of that tripartite angle. And that's all I was going to say. And in fact, that is an obligation which states that have ratified labor inspection conventions, the ILO, for example, have. And that is quite different from the political alliances, I think, that you're talking about, which I won't comment on the success or not. But I do think from experience, where labor inspectorates benefit from worker and I should add, employer perspectives, outcomes are better.
Thank you, and that is also one of the pillars of the ILO, no? The International Labour Organization, is this tripartite structure that of course has some disadvantage too, no? Because it maybe slow the process of ratification, the discussion, but also one of the big advantages is that because this tripartite structure is more legitimate. No, it has more enforcement in theory, at least, no? Because the three parties were agree with those convention and recommendation. No? Thank you for that clarification, Rua. And now we are going to go with Ian. Please go ahead.
Yes. Good morning, everyone. While I agree, there are a fair bit of a fairly robust framework in place, somewhat for enforcing human rights, particularly in the Caribbean. One of the issues that we have to date, a lot of it has to do with the justice system. Is there any specific ILO convention that actually deals with the issue of legal aid? I know it's more of a complementary type of issue, but a lot of times, you know, the old saying, justice delayed is justice denied. Normally, a lot of this takes a long time to resolve, and the workers actually suffer over a period of time, or they get frustrated and move on. And you also have the same system, particularly even in the case of unions, even though they may have their lawyers. Because these things drag on for a long time, particularly when you're dealing with multinational corporations, they definitely need to be supporting mechanisms such as legal aid to supplement that. Particularly not, even in the case they are not, unions are not involved. Could I get some feedback on that, please?
Yeah, absolutely. Thanks for that question, Ian. I think you hit the nail on its head basically. With this is a critical. It's a critical point, and it's interesting that you raise this now because one of the things that the international labor movement, the global labor movement, is doing at the ILO level and also at the UN Human Rights Council level is pushing for regulation of global supply chains. And as part of this, at the ILO level, we've been calling for an instrument, a convention governing decent work in global supply chains. And separately at the UN Human Rights Council, we're fighting for the so-called binding treaty on business and human rights. And both of those efforts look to tackle the issue of access to justice for workers in global supply chains, both at the domestic level, but also perhaps against a lead firm or a company at the top of a supply chain domiciled, say, in the global north, perhaps. And that's specifically for dealing with barriers to justice based on companies that may be domiciled abroad. But even domestically, of course, what we see is workers not having access to a remedy, a judicial remedy, because of barriers, including funding issues. So while there aren't ILO conventions or recommendations dealing precisely with the issue of legal aid or support for claimants per se, general principles of the ILO, including through its various declarations, would lead us to that particular issue. And in fact, there's many general surveys of the Committee of Experts that do tackle this particular issue. But what I would highlight is that, of course, there are the international covenants on civil and political rights and economic and social and cultural rights, which of course cater for the need for access to justice and how claimants and individuals generally need to be assisted. So there is scope to argue that we need issues like legal aid to be discussed, basically. But we have recognized that there is a gap when it comes to international labor standards on this particular point. And that's why we are advocating for new ILO instruments on decent working global supply chains, which will also deal with this issue around access to justice and financial aid.
Thank you. I have a quick follow-up question about that, because I don't know if that happened in other countries, but in Peru, something that usually happens is when a company get a resolution from the labor inspection against the company, what the company has, because they have an army of lawyers, they try to push that resolution into the judicial system. So in that regard, when they put that in the judicial system, that the resolution is waiting for the final instant in the judicial system, that can take like 5 years. So I don't know, according to your experience, if you see that connection in practice, and what could be some of the solution or challenge for workers. Thanks.
Yeah, no, thanks, Louis. I think that experience is shared by workers and trade unions in many jurisdictions. But I've got to say, I mean, of course, from the sounds of it, the labor inspectorate in Peru does have enforcement powers, right? So that's in itself is something positive, which not all labor inspectorates have. Nevertheless, yes, I mean, what we find is, especially when there's hefty fines or remedial measures requested, these remedial measures don't happen immediately, because, of course, the employer challenges the decision or enforcement measures of the labor inspectorates. And look, there's ways of fighting this. I mean, one thing which we regularly ask for at the domestic level is for interim measures. So if a particular issue, and this usually happens around fines, so financial penalties, drags on for a while in the court system, we would ask courts to put in place interim measures, which will require the employer to take remedial action at the shop floor, at the work floor level, which will have an immediate impact, say, on an occupational health and safety issue, while the issues around compensation or fines can be dealt with through the court process. So I think there's ways of doing this, but fundamentally, the problem is with unscrupulous employers who, rather than doing the right thing, would prefer to drag these issues through the court system. And we need to hold them to account, saying that, quite simply, you can choose to do that, but a better way of doing things is by addressing the real issue, making a difference for workers on the ground. And this is also where I think, talking about HRDD and supply chains is when we would then tell the lead firm at the top of the supply chain, hey, look, this is what the supplier is doing at the national level, and you're sourcing from them. Use your leverage. Use your leverage. That's what HRDD is about. Ask them to not drag this through the courts and try and find a resolution on the ground.
Perfect. Thank you. Thank you for that clarification. If anybody has another question or comment, please go ahead. Philip?
I hear you. Okay, here in South Africa, during when the trade unions were powerful, when a worker was attacked by fired in an unfair way, all workers will stand up. All workers will go on strike. If one worker is fired, all workers will decide you must fire all of us. And in that time, the trade unions were very strong. And then now we have what's called CCMA, Commission, Conciliation, Arbitration, and so on, which is government. It's a government institution, and it is meant to protect the interest of the workers. And instead, what's happening? Workers' interests are being not properly protected, and then workers are even advised you must just take whatever your boss is going to give you and leave, because if you don't take that, you're going to lose. You're not going to win this case. And we see workers' rights are increasingly being compromised. So isn't what you're talking about maybe what's the difference to what the CCMA it is doing here in South Africa? Or, how do they work together? Thanks.
Thanks, Philip. Yeah, I mean, I think you highlight two issues, perhaps. I mean, first is trade union power, trade union militancy, and also the issue around conciliation, mediation, and arbitration. I mean, with the former, what we see around the world, of course, especially since the 70s and the last 40 odd years, 1970s, is it the 40 or 50 years ago now? I can't losing track of time. Is of course major reversals in employment protection and trade union laws, which have seen the power of trade unions diminished across the world. I mean, this is across the board, right? So that has, of course, led to various issues, and I'd say that as a trade unionist, the curtailing of the right to take secondary industrial action, for example, in my view, has led to many more industrial issues, industrial injuries and issues of that nature than when you could walk out, right, based on one or two injuries, because an injury to one is an injury to all, and that very much is our motto. So that issue also has to be dealt with. Of course, we're always campaigning for more progressive labor laws, for more trade union freedoms. So that has to happen. But on the other hand, I can't comment directly on the CCMA. Of course, our affiliates have used that body to mediate and conciliation before taking strike action or before using the labor courts. And generally speaking, I suppose as a labor lawyer myself, I do see advantages in conciliation, mediation, and arbitration services, also for the very simple reason of cost. Usually these services would mean that we can find a quicker resolution without going through the more burdensome and cumbersome judicial processes. And I can say honestly that we have had positive results. Of course, it depends on the makeup of such bodies, the expertise that they have, and whether they are genuinely there to resolve conflict or to represent the interests of capital and employers, right? So I think I'd leave it at that. But broadly speaking, I would be quite supportive of conciliation, mediation, arbitration services that have the legitimacy and confidence of the parties.
Thank you for that comment, and I think that this is very important. In Peru, we have now a mandatory arbitration in the frame of the collective bargaining process, and that helped to reduce this asymmetry of power, no? Because the workers unions sometimes are weak and they cannot make a big strike, no? So in order to be able to negotiate, arbitration can help. No? Well, Tia, do you have a question? Please go ahead.
Yes, hello, everybody. Sorry, I was not following from the beginning, but I was watching your video, Ruwan, and I was very much enlightened and very clear to me your message about tripartism and the need to include the state in improving access to justice for labor. In Indonesia, actually, the situation is not different as that what our friends already shared with you. For us, labor court looks like a graveyard of labor cases. Yeah, and most of the cases brought to the labor court were actually a follow-up of the recommendation given by labor inspectorates after dealing with reports from trade unions. And they try to follow up, they try to bring the mediation process, but as everyone said, they are very bad facilitated, and actually not only budget-wise and knowledge, but also their mandate. They don't have any mandate to bring or to say to set any sanctions. Even companies, if they are not responding to any invitation to mediation, they can't do anything against it. So we in Indonesia, we initiated with trade unions and legal aid bureaus the idea of criminal labor law. And this had taken place for 3 years. And the main obstacle we saw was the police. Because police seems to either they really don't know or they play the unknown person about what is a criminal delict in with regard to violation of freedom of association, which we have in our law actually stated it is a criminal delict. So the first advocacy what the union did is why we don't set up a labor desk at the police office, at the central police office. And it was set up, but without any follow-up. So you have informal, you have a labor desk at the national police headquarters, but you don't have like the labor inspectorate, it's only an entity. It's only a name without a content. So what I was wondering is if you have also some information about labor criminal law applied in other countries, and if you have any observations about this, first, and secondly, what do you see the projection or the opportunity of human rights diligence law in Asian countries? Because this is something coming from the Western, from the rich countries, right? And here in Asia, we only have suppliers, and suppliers, they are not transparent whom they are supplying to. In trade union, they don't have any power to access any of this information. Even buyers are not always open about their own supply chain. So that's my question. Thank you.
Thanks, Tia. Thanks for your reflections and your questions too. Very big questions. Maybe I can say very quickly on the use of the criminal law in the labor sphere. Of course, when it comes to crimes such as forced labor, human trafficking, child labor, or indeed, we would argue in some instances on occupational safety and health, where there's issues, we can argue of industrial manslaughter, for example. So that's a negligence leading to deaths or major injuries of workers. The criminal law can play a part. This is certainly something that we are calling for. Let's just say that 4 of the industries where my members are among the 10 most dangerous jobs in the world. right? From commercial seafaring to trucking. So for us, this concept of industrial manslaughter, so bringing the criminal law into this space of occupational safety and health is very, very important. And there's only very few places in the world where such laws exist. And one of those places is Australia, for example. So we do see a role for the criminal law to play. But one thing I would say is that in many countries, if we look at some of our sectors, migrant workers make up the vast majority of workers in our sectors. And the involvement of the police or the authorities when it comes to labor matters could sometimes be a deterrent for them in approaching them because of fear, the general fear that migrants or minorities have of the police and the authorities generally. So that's why, in fact, it's relevant to this discussion on labor inspection as well, when a lot of countries, labor inspection regimes work directly with the law enforcement authorities like the police. And for us, that's a bit of an issue, especially where labor inspection authorities work with the police and say immigration enforcement, when they might go and inspect a factory over health and safety issues, but then they end up rounding up migrants who may not have the papers. So that I think is a nuance that we need. While of course we support the use of the criminal law in the labor sphere, and we need to be quite careful about having law enforcement involved for things that go beyond their remit. And perhaps very quickly, and it's a very big discussion on HRDD laws and how they apply in the global south. You're absolutely right that if we look at mandatory HRDD laws right now, we're literally talking about Europe, Canada perhaps, with some initiatives in other places. But for us, the most important thing is, and I'm speaking as a trade unionist here, is that HRDD not only leads to better prevention of human rights abuses, but it also leads to increased industrial power on the ground, that this actually empowers trade unions, it empowers workers, and it can increase collective bargaining coverage. And this is fundamentally what I think the outcome needs to be. And we have models like, I'm sure you've discussed the Bangladesh Safety and or the Fire Safety and Health Accord, which is now seeing the Mark II, which is the International Alliance, which as we speak, I think I just saw that the 154th company had signed up to this accord, which now goes beyond Bangladesh, right? So that particular model shows that it's not only the brands themselves, it's not only the suppliers, but it's also the trade unions on the ground who are affiliated to the global unions, have an intrinsic and important role in enforcement, but also it helps them build capacity with the workers at particular sites to help organize, to help build capacity, which then increases collective bargaining coverage and increases union strength. So I do think there are models that exist that can use HRDD to empower workers and unions in the global south so that we can see positive change. And it's not that HRDD laws aren't just used by companies to sell more products by branding themselves as ethical, if you know what I mean, right? So I do see that the potential of HRDD to increase union power and of course ultimately workers' rights in the global south.
Thank you, Ron. And this is yes, and that is very important because we don't want that the HRDD became in a new sophisticated way of social responsibility, right? We want something that is really enforceable and is going to empower workers, in that process. It's not just like unilateral action from the company. So that those remarks are very useful. Please, if there is any other comment or question, go ahead. Yes, please, Benji. And then Adida.
Yeah, thanks, Luis. And hi, Ruwan. So, going back to the question of like cooperation between the inspectorates and unions. So here in the Philippines, there was I would call a reform. This was a demand, long demand from the labor movement. Around 2015, the government decided to deputize unionists, but not just unionists, also representatives from employers, NGOs as labor inspectors. So I think a couple of years ago, there was mention that more than 200 were deputized from outside of the ranks of the formal labor inspectorate, which is a large number actually, because more than a decade ago, there was just that number of labor inspectors in the Philippines. Although now I think it's for the formal is around double. Okay, so although the problem now is they haven't really been activated before they can actually do inspection. These deputized labor inspectors should have what's called here mission order. So they have to be formally notified and sent on a task to go and inspect. So from what we know of the labor unionists who were certified as inspectors, they said that they haven't actually gotten any mission orders. So I guess the problem now here comes to the question of basic, at the end of the day, political will. Is the government actually serious in actually using unionists as a complementary force to the formal labor inspectorate, which I guess is generally the case in the Philippines. We have a robust enough set of mechanisms, labor standards, labor laws, even ILO convention. I guess the Philippines is one of the had ratified the most number. I'm sure more than the US because the US hardly ratifies any. I remember, if I remember correctly. The problem is this disconnect between like law and practice, right? I know that's the term they used. I say this not to denigrate the fact that those mechanisms are important. I'm sure without those mechanisms, we'll be in a worse situation. But the problem is, of course, even despite the presence of mechanisms, you still face problems. So this is more of a sharing rather than a question, really. Although I think what's happening in the Philippines probably goes elsewhere, right? So I don't know if you have any insights about that. Thanks.
No, thanks very much for sharing that with us, Benjamin. I think that's a really important observation of what sounds to me like a pretty positive initiative by the government 5 or 6 years ago, and it just hasn't materialized. And I think, as Louis was highlighting earlier, you know, with Peru's budget of 0.07%, and for the Labor Department, it is a question of political will. And when it comes to labor inspection, what we see generally around the world is precisely that. It's when it comes to prioritizing, it never gets the attention that it deserves. And this is I think also something that trade unionists, civil society, workers need to also campaign at the national level, right? And also reflect that at the ballot box, perhaps, that this is a very important issue. You know, I mean, and this is not an issue that is endemic to the global South. This is very true of the global North. I mean, I used to live in the UK. I lived in the United Kingdom for 15 years. The United Kingdom does not have a labor inspectorate. Can you imagine? Can you believe that? The UK does not have a labor inspectorate. It has a health and safety executive. It's not a labor inspectorate. In Italy, this week, we just heard that there was this, I think it was the 772nd death on the job. And this was at the end of August. So I think they're saying that usually, this unfortunate statistic in Italy was about 1,000 workers dead per year on the job. It's going to be far more this year. And part of the issue is around lax labor inspection. So this is not just, again, I don't think we need worker deaths to be the incentive to fight for better labor inspection in law and practice. But hopefully these tragedies will push governments to identify labor inspection and enforcement as a key priority.
Thank you. Before going ahead with Adira, I just want to comment in the chat. No, they are writing that in the Caribbean, in Uganda, that is very common that the companies take the cases from the inspection to the courts. No, and that can take long time and in practice make ineffective those resolutions sometimes. No, so please, Adira.
Yeah, I mean, just to join to the disastrous situation of labor inspectorates in my own country, in Albania, we don't even have a Ministry of Labor. So the socialist government just dissolved the Ministry of Labor, put the labor inspectorate as part of the Ministry of Health. And it's a total mess. But going back to the very interesting video lecture that you, Ruwan, presented for us, I wanted to ask you a bit on these auditing companies. And I mean, you touched upon also how problematic they are. So the question, you're not saying directly that they shouldn't exist, right? So you're kind of thinking of bringing them under some sort of supervision and from the labor inspectorate. But ultimately, would these companies need to be there if we have strong labor inspectorates? So if you have proper financing and structures which involve also workers and their organizations and employers. I just wanted to hear your thoughts on that.
Yeah, thanks very much for that, Adlira. I think that that really is a critical question. It's very interesting. I always find that lead firms at the top of supply chains, the big brands and retailers, rely so much on third-party social auditing because they say that national labor inspection services aren't robust enough and that they can't rely on them. Yet, as I think I said right at the outset, if some of these companies paid their taxes properly and in the right places, maybe those services would be better, right? So it's kind of a circular argument. The truth is, as you suggested, Adlira, I think if we do have fully functioning labor inspectorates, there probably won't be a need for third-party social auditing. But the reality is right now we have them. And what I think I was talking about in the lecture was how we regulate them, because we hear about the failures of social auditing when it comes to major disasters, right? So this was the case at Rana Plaza. It was a case most recently this summer in the factory fire in India, where the factory again was audited, I think 3 or 4 weeks before that particular fire. So a lot of these social auditing exercises can sometimes be tick box exercises where inspections aren't carried out properly. There's no workers interviewed on the ground, and it's very much company pays, I give you an auditing report that is to your satisfaction. So there's a clear conflict of interest if a company is paying for their own health and safety or labor checks, right? I mean, it's very, very simple. So what we're trying to say is that, yes, we understand there is a third-party auditing industry. Then, especially if we have mandatory human rights due diligence legislation, say at the in a particular European country, let's say Germany, right? So Germany just established a law, but it does not have this this sort of enforcement body that I was talking about in the lecture. Unfortunately, it doesn't have that, although we lobbied very hard for that. So what we're saying is, if there is such a body, a tripartite body, and there are, we know that companies from this particular country are relying on third-party social audits, what we would expect as a minimum is that there are integrity standards to which the social auditors need to comply with, without which they cannot have a license to operate in that particular supply country. And you will only have that license based on these integrity standards, which need to be developed, of course, also in a tripartite fashion. And that these auditing companies are registered and licensed at the national level, and that they cooperate and work with the Labor Inspectorate, and they send their reports to the Labor inspectors for verification. And only then can they be truly relied upon by companies that are sourcing from that particular country. Because otherwise we're going to end up with more disasters. We're going to end up with more sort of tick box exercise type auditing reports. And we think that form of regulation is critical, because right now that regulation does not exist at all anywhere in the world. So again, this is something we're asking for both at the UN Human Rights Council level and at the ILO level in the regulation of decent work in global supply chains.
Thank you. Thank you for that comment. I think Tia has another question. Please go ahead.
Yeah. Thank you, Luis. Ruwan, well, this is something which is coming very much in surprise. I also only heard it recently. Here in Indonesia, apparently there is a trend, or let's say an organization. They conducted a research and they found, they revealed that labor cases have better chance for success if they are brought by workers directly and not by their trade union. And I wonder if you have heard about this, and what is your opinion about this, and what can trade union do against it?
Well, I mean, yes. Again, this all depends, on the national legal system. And in some countries, it is difficult for trade unions to act as a claimant effectively in a collective case, right? So they can support individual workers to take their cases, so on and so forth. But in my view, in jurisdictions where trade unions can take employers to court over a violation of a collective bargaining agreement, if it exists, I think that's quite simple. But where there is no collective bargaining agreement, a bit more difficult, of course, but it should be a viable route. Is it the case that it's easier for an individual worker who may be aggrieved to show legal standing to bring a case? Then probably yes, and that's probably it could be to do with rules of procedure in the civil courts and labor courts. I'm not sure exactly what the situation is in Indonesia, but yes, I mean, I'm sure it's a very real issue. But what I would always argue is that trade unions, as representatives of workers in a particular workplace, should have legal standing to bring cases on behalf of their members and workers in that particular workplace. Sorry if I didn't. Sorry if I didn't answer that question fully. Yes. I think that they should have standing. Absolutely.
Yes. Yeah.
I mean, if I may, I think it would be also interesting who did the report, because I think that also seems to be interesting. Yes. Yeah. Well, who is paying for the report?
With whom trade unions often work with.
Interesting.
So this still has to do with the investigation about performance of labor courts in Indonesia. And very surprising, for me also, very much surprising. Yes, we are still trying to find out how verified this information is. I just wanted to know if these kind of observations also happen in other parts of the world. Because it sounds quite logic, right? The trade unions membership numbers decreasing and the leverage in the, I know, in a negotiation is also not getting stronger. It seems for me quite logic. But it is sad. It is actually sad if we have not anticipated the situation, because my government, they just have passed an omnibus law last year where they really took out all this co-determination position of trade unions, including negotiating about wage reduce during like COVID time, where COVID pandemic, where they said it is not necessary to have the trade union representative as long as the workers directly agree with this deal. And this is this is a bill, yeah. This is a very new one. So co-determination is very much under threat this time.
And I think that's sorry to come in, but that's a really good example of things we've been observing happening around the world. And I can share perhaps with the group later, Edlira and Lewis, a paper that I wrote with another colleague who had a module in this course, Jeff Vogt, and we wrote a piece about regressive labor law reforms during the COVID period, where COVID was used as a guise to pass regressive reforms, and unfortunately there is there's quite a long list.
Thank for sharing that document. I just the last question. I think we are almost on the time, but what about labor brokers? I mean, the question is, what about the labor brokers? Do they have future in the HRDD mechanisms? How is your experience about that, including them in that? Thanks.
Yeah, thanks for that question. I think it's from Philip. Yeah, thank you for that question. I think it is interesting that I think from an HRDD perspective, and Western, or not Western, but brands or retailers, lead firms from the developed world, from the industrialized countries, this seems to be an area that is of great interest to them, and where action has been taken, right, on recruitment generally, where they understand that the use of private employment agencies, labor brokers, both formal and informal, has led to significant adverse human rights impacts of workers. In the fishing industry, which is an area that I work in, this has been a major issue for the big seafood companies, of course, right? Because when we started bringing information to them that informal, illegal labor brokers were trafficking Burmese, Laotian, Cambodian fishers into Thailand, for example, it opened their antennas went up, and then they started dealing with the issue. So I think now with issues like the employer pays principle, which has become very, very common across the board, that a worker should never pay any recruitment fees. We're seeing that this particular issue is being taken very, very seriously by a lot of the lead firms that we work with. In 2015, in fact, I was part of the team that developed the ILO's Fair Recruitment Guidelines, which is a fantastic document, which really shows what the obligations of states are in relation to employment agencies, but also what employers can do and what their responsibilities are. So we use this very often with lead firms in the HRDD processes to say that unless you look at the question of recruitment through this particular lens, then you are not really complying with your obligations. But I do think that thanks to HRDD processes since 2011, when the UNGPs came, were published, we are seeing more action in this space. And I do think that many unscrupulous labor brokers, especially informal ones, have gone out of the scene because of action at this level. So I think this might be one of those really rare occasions where we can say that there's been some progress thanks to these developments.
Thank you. With that positive reflection about the HRDD effects, we finished this workshop. Thank you, Rob, for your time, for answering the question.